Thank you for the nice introduction. It's a great pleasure and honor to be here in that beautiful place. I find it very difficult to not get distracted by the view because it's like calls you out to go to the seaside. When Zana Petersone asked me last October, November, when she came to Alicante, whether I would be willing to talk to you sometime this year, I was very delighted. So I'm grateful for her to suggesting my name, and I'm also grateful to the Latvian Patent Office to have taken up the proposal. My presentation has basically 4 parts. I will start with the design law reform in very general terms, because we are still at a very early stage. I move on to some of the judgment of the Court of Justice, which I think might have an impact on the legal reform, followed by 2 judgments of the General Court, which in my view touch on interesting issues not decided before, and then finally present you 3 cases of the Boards of Appeal, which are all pending before the General Court, so we might hear of them again. So, starting with the design law reform, I first would like you to have a look at the timeline to get you an idea where we stand now. Leaving aside the preparatory work, the green paper and all that, we had the Design Directive in 1991, which was implemented until 2001 in all of the member states, followed by the Community Design Regulation, the CDR, 2001. 2004, we had a proposal by the Commission with regard to spare parts, which, as you will know, is still an open issue. That proposal was, after 10 years, abandoned in 2014. 2006, the first and so far only amendment of the CDR with regard to international registration due to the accession to the Geneva Act. And then in 2014, the Commission initiated basically the review process in very similar manner as it did with trademarks, in commissioning an economic review finalized in 2014 and a legal review, which was done in 2015, published in 2016, but the state of play, taking into account, is that of 2015, basically. In the meanwhile, we had the EU trademark reform, 2016 and 17, which of course gives rise to inevitable changes that community design should be called the EU design in the future, and also some procedural provisions certainly should be aligned for designs, but that's not happening now. And this year, the Commission launched what they call the evaluation roadmap. In the jargon, in the Commission's jargon, that is a tool to inform the public and stakeholders about the work of the Commission and to allow them to participate in the legislative work. So what does it consist of? It consists of several surveys, one for the general public, stakeholders and professionals. We have finalized, EU IPO is participating in those works, so we have submitted draft for all these surveys end of August. There will be public consultation. In the framework of the roadmap, major user associations have commented on the legal review, and as you can see, it is still very much the state of debate. The legal review has not given concrete proposals how to redraft or amend provisions. So we're not talking about a paper which already gives you an idea what the future directive or the CDR, then certainly the EU DR will look like. And this is why I will not go into too many details, because from my point of view, everything is still very open. The legal review had explains that it used a cascading methodology. That methodology has been criticized to a certain extent for lack of representativeness and also for lack of transparency. And I think it's, if you read the review, and I have just noticed that the link is not included, but if you search for the legal review on design protection, it will immediately come up. They first started with what they call a legal desk research. So it was an external contractor. There were professors, for example, from Queen Mary in London. There were consultants. They did legal research at their desk in 15 member states. Followed by stakeholder interviews. For example, people at the UIPO got a telephone call and were asked questions about design invalidity and registration proceedings. And on the basis of the issues identified on the first layer, then they made the second layer data collection. So number of designs filed, number of individual designs in multiple applications, number of designs renewed, things like that. And a legal analysis of the legal provisions in existence so far. On that basis, if we look at the substantive law questions, I have listed you those which have given rise to most discussions, which are the most controversial ones, and which to a certain extent have been answered by court judgments issued after the legal review. So to a certain extent, some of those recommendations are also redundant. So definition of a design. The review suggests that tactile and visual aspects should be protected. This has been criticized, particularly on the tactile aspect, because, as we all know, design protects the appearance of a product. So tactile, in the understanding of the majority, should only be protected to the extent that you can see it from the appearance. Like if the material of the design is evident from the representation, obviously it makes a difference if the product is made from steel or from fur. That can have an impact on tactile, but that tactile is misleading in that context. The second one is only visible designs to be protected. Here the reference is made to the broken biscuit judgment of the court, which you maybe remember, where the biscuit was represented in a closed form and in a broken form. And in a broken form, you could see that it had a soft filling, and then the court and the boards of appeal before and the court later, they said the filling is not to be taken into account because it cannot be seen when you buy the biscuits. And the study comes to the conclusion that the visibility requirement creates confusion, and it should be made clear that only aspects which are visible can be protected. That has given rise to a lot of protest, because you have many designs which, when you buy the product, you can see all aspects, and then you build it in, or you have a lamp which is fixed to the ceiling and then you only see a part of it. Should only that part be relevant? So it's a lot of discussion here and no clarification from the court yet. I agreed with the translators that they give me a sign when I'm going too fast, but I can't see them. So maybe they have to come out and let me know. The next one is the effect of the product. This touches upon the topic to what extent the product to which the design is going to be applied has a relevance in the assessment, in particular of individual character. The study suggests that the product should be taken into account, the manner in which the product is used, and the relevant industrial sector when you assess individual character, which obviously could imply that if you're conflicting designs referred to separate products, that they necessarily is individual character. That question has been answered to a certain extent by the Court of Justice in the shower drain judgments, which we will see later. So again, we will certainly not only look at the legal review on that issue. Technical function. How do we assess technical function? That means the question whether a design is solely dictated by technical function and therefore not protectable as a design. The review suggests design freedom, the question to what extent the designer had a choice of features to be the relevant criterion. Again, here we have a judgment from the Court of Justice, a Dizainparauga judgment, which addresses those issues and comes to a different conclusion. On spare parts, the spare part provision in the CDR so far is Article 110, which tells you that there's no design protection for a product used for the purposes of repair. And the review suggests to move that to Article 20, meaning rephrasing it as a defense to infringement. So finding a final solution for spare parts and limit it to spare parts which must match, which are dependent on the appearance. Again here, a judgment with a different conclusion to be seen later. And finally, on the copyright issue, and I'm not sure whether Thomas will touch upon the problem of accumulation of rights, the Floss judgment made it clear that design protection and copyright protection are not mutually exclusive. A design can be protected by copyright and vice versa. And here the review suggests that all the member states align this judgment. And I must admit, I'm not aware of the situation in Latvia, but that might have an impact on your national law. And I will not go into copyright in detail because at the office we deal with it very, very rarely, and we entirely rely on national judgments on that respect. Having shown you the controversial positions on substantive law, there are of course many other recommendations which are far less controversial and I think are very likely to find its way into the reform. The first one, that the national registration system should be retained. I think that's common agreement, common ground between everyone, and the study explains in great detail why that combination of national and European protection has proved to be very useful. Invalidity proceedings should be offered at national level. That might have an impact on. I understand that probably until now you do not have not invalidity proceedings. I'm not sure, but so that could have an impact on your national law, and obviously will only affect the directive, not the community design regulation. A common deferment period throughout the member states. The period for deferred publication is 30 months on the community, on the union level, but it's not 30 months in all the member states, which obviously leads to problem. That should be aligned. A comprehensive review of the impact of 3D printing. When coming here by bus, I discussed it with Tom, and 3D printing is a very fashionable topic, although we don't really know how big the impact on design protection will be. The Commission has launched another study, and of course stakeholders have an interest in clarification to what extent you can enforce your design against 3D printing. So that's certainly a provision which will be included. On the community, on the union level for Alicante, it's important that the 7 views requirement will be eliminated. We have a big problem there. If you file an RCD, you're limited to 7 views. Many countries also outside the Union do not know that limitation, for example, the US and Japan. So if you claim a Japanese priority, that's always a very tricky exercise to choose those 7 views from your first filing, which still will maintain the identity of the design. And it's common understanding that that requirement should be eliminated. And 3D representations only to be introduced as an option. There are countries, because the EOIPO in Alicante is also involved in cooperation with what we call the five biggest offices. That's China, Korea, Japan, the European office, and Alicante. And in that context, for example, Korea and Japan, they have the possibility of 3D representations being filed as a good version, and this is a discussion whether we should accept that or not. But the proposal is to introduce that only as an option. This is the situation at the office in the moment. You can file an animated view of your design, but nevertheless you have to identify 7 static views which show the main perspectives you would like to present. I will leave it here, and I will, just as a final remark, tell you my personal impression. And from my experience and from the case law, I would say, in essence, the community design regulation has worked quite well so far. I would, of course, be very interested in your feedback, because at the office we see registration, we see invalidity, but we don't see the infringement side. So I personally do not expect major changes on the substantive law. We also have to bear in mind that the corpus of case law we have received from the Court of Justice, unlike in trademark law, is still very limited. So not many judgments which really oblige us to introduce changes. Unlike in trademark law, where, for example, the requirement of graphic representation was clarified by the court and called for an amendment. So if you have questions on that reform, then I would move on straight to the judgments, which I think are more concrete, starting with a picture of the court building. If you ever have been there, I went once. I think it's rather impressive, and it houses both the Court of Justice and the General Court. But I will start with the Court of Justice. With the shower drains judgment. That is a judgment issued in proceedings which started before the office. It touches on several issues, but I think the most important one is with regard to visibility and the relevance of the product indication. What we saw before, what is the effect of the product to which the design is going to be applied in the context of the validity of the design. This is how the case started, and I put it as a first slide because I think it's important to understand the case in its context. So on the right you have the contested RCD filed for shower drains as a product indication. On the left you have the prior design invoked, which was a design of the RCD holder. So what the invalidity applicant did, he took an earlier design of the design holder and said on that basis it should be declared invalid, focusing particularly on the cover plate and saying that the slots on the cover plate are purely technical, and if you disregard those purely technical slots, the flat cover plate is almost identical. That was the argument with the invalidity application. Then, before the invalidity division took its decision, the representative changed, the representative of the invalidity applicant changed, and he submitted additional material to illustrate that a flat cover plate is very frequently used with regard to those drains. And among the pictures he submitted for those illustrative purposes, was this picture, which is for drain collectors for industrial waste. And it was on the basis of that picture that then the first instant decided that the RCD lacked novelty, so identical designs, because the cover plate was the only element to be seen once the shower drain was installed. The case then went to the Board of Appeal, and the Board of Appeal annulled the decision and said, no, there's not identity, because if you look at the contested RCD and you look at the cover plate, you see those small lines, parallel lines on the sides. And since the cover plate was the only visible part, and that was a part on which the informed user would focus, you could not talk about identity, and the case was remitted for the examination of individual character. And that's why we have 2 appeals to the Court of Justice, and that is why I personally find that the read of the judgment is very complicated, because the design holder appealed against the declaration of invalidity, and the invalidity applicant appealed against the remittal of the case for further examination. The General Court then annulled our decision and said we had not properly identified the prior design, and we had not taken into account the difference in product between a drain collector and a shower drain. And then again, there was an appeal, this time from the office, because the General Court had told us that we should have identified from the pictures submitted the full product, not only taking into account the cover plate, but also the other element. And we were not happy about that obligation. And of course, the invalidity applicant appealed because of the annulment. So what did the Court of Justice say in the end? On visibility, you find on the left the relevant provisions, but this is only for your ease of reference. If you go to the slides later on, I will focus on the right part, and I'll invite you to do the same. So visibility is an essential feature of protection. I think we all agree on that. That is not disputed. Then, unfortunately, the court made a reference to Recital 12, and Recital 12 refers to the visibility requirement in component parts of complex products. This is a statement they make, which as such is correct. It's correct that Recital 12 refers to component parts of complex products, and that in their assessment you only look at the visible part. But what the court did not address is that a shower drain is not a component part of a complex product, because the floor in which you install the shower drain is not a complex product. I mean, the shower drain is not installed to assemble and reassemble. I mean, this is not usually what you do with a shower drain. This is the irritating bit of the judgment, and it has been taken by some voices to say, okay, here the court said only visible designs should be protected. But my reading is rather that this statement has to be was made very much in the context of the specific facts. And since the case started, quite unfortunately, being very unclear of what we are looking at, I think it should only taken in that context, meaning that in the case of a shower drain as examined, of course it's important to put emphasis on what you see. Having said that, what they said as a further obligation for the invalidity applicant, that it's for him to clearly identify the prior design relied upon. And they concluded that submitting a variety of catalogue pages is not clear identification. Here, of course, we have to add that had they had an entire look at the file, they would have found that the case started wrong from the outside, because the first prior design invoked was clearly identified, but that issue was not raised by the invalidity applicant himself, so it was not taken up by the court. This happens very often, that if you do not invite the court to look at the details, they will not go into it. So since the invalidity applicant submitted an incomplete reproduction in the way that he only included a picture of the cover plate and not a picture which showed us the full product of the drainage device, he did not complete with his obligation to substantiate his application. You will see on the left the relevant provision on substantiation, and it's his obligation to clearly identify the product, the prior design invoked. And it's not for the office. This is a part which is very important for us, and would be interesting to see how you deal with that aspect in infringement cases. It's not for us to construe from the entirety of the invalidity applicant's submissions a possible prior design. If it's not clearly identified, then it cannot be invoked. So that for us is useful. The conclusion of the Court of Justice, nevertheless, was that the General Court rightly annulled the decisions, because the Board of Appeal also had taken into account only the cover plate, and therefore had also and made an error on its side. The next issue, obviously, was, is it relevant that one of the prior design referred to drainage device for industrial waste and the other one for shower drains? So what is the relevance of the product to which the design is to be applied? And here, with regard to novelty, and with regard to the provision of Article 10, 19 and 36, which talk of designs in general without an emphasis on the product, the court found that if there is an identical earlier design, the product doesn't matter. That for us is very useful and important statement. So in the assessment of novelty, the product indication is irrelevant. This is in line with what we say in 36, paragraph 6 of the CDR, that you have to indicate the product, but the product indication does not affect the scope of protection. Basically, the design can be applied to any product. This is for novelty. And what does it mean for disclosure? The General Court had argued that we had not taken into account in our assessment that for disclosure of the prior design to be established, we would have to show that the informed user of the RCD had a possibility to take note of the design for the prior product, which means basically, if you are the informed user of a shower drain, we would have to show that as an informed user, you're also aware of drainage devices for industrial waste. And here, again, making a reference to the wording of Article 7.1, which does not include any reference to a product, but only talks about the publication of the design, the court made it very clear that the disclosure is independent of the product. That means for the design corpus to be taken into account, the product is not relevant. If there's an event of disclosure, we assume that the informed user knows it. So the sector concerned is not limited to the product of the RCD. And it's also, and that was an important finding for the office, it's also not important that the informed user of the RCD knows the other product, knows the product of the prior design. So far, so good. I hope most of you would agree. Unfortunately, they did not discuss what it means in the assessment of individual character, because this question was not raised, not by the EU IPO in its appeal and not by the invalidity applicant. So what are the conclusions? The conclusions are that the prior design must be clearly identified by the invalidity applicant, not by the office and not by the court, I would say. That the difference in the product are irrelevant in novelty and also in establishing the design corpus, so in establishing what are we taking into account as prior designs. And with regard to the individual character, they did not take a decision what it means for the informed user. My personal approach would be, and this is what we do at the Boards of Appeal, that we assume that the informed user is aware of both product categories, and that means he's also, to a certain extent, might be aware of technical limitations, might be aware that the product categories are very different, but that he still will be able to make a direct comparison, so that the fact that the products are different is not automatically justification to grant individual character. This is the approach we have taken so far. We have one decision pending before the court where we hope that we get confirmation on that point, but the shower drains do not address that issue. And the final decision, because since the Court of Justice dismissed both appeals, the appeal of the office and of the invalidity applicant, so the final decision in the shower drains is still pending. And I understand it's going to be notified in the next couple of weeks. And it also shows you that if you don't look at the proper prior design in the first place, the case can go very long way. No? The next judgment. This time a preliminary ruling on technical function. You will remember that technical function was one of the issues addressed by the legal review. A request for preliminary ruling from a German court. On the right you see the accused designs, and on a counterclaim by the owner of the accused design, the RCDs on the left were declared invalid for technical function, for features of appearance being solely dictated by technical function under Article 8.1. For those like me who don't really have an idea what a welding pin does, it's used in particularly the automotive industry, and it's basically the idea to fix the piece you're going to weld on the metal sheet in a specific position. This is a picture taken from the RCD holder's webpage. And if you go to the webpage, you will find many more details on welding. Article 8.1, you see on the left, features of appearance solely dictated by its technical function. And the court asked two questions. Is the existence of alternative designs decisive, or must it be established that the technical function was the only relevant factor when designing the design? And what is the relevance of the perception of the objective observer? So to understand those two questions, you must know that there were two competing tests for technical function. One is a so-called multiplicity of forms test, which basically says if there are alternative designs to achieve the same technical solution, then the design is not solely dictated, the features are not solely dictated by technical function. And the competing test is that introduced by the Boards of Appeal in the chaff cutters decision, which assesses from the standpoint of a reasonable observer whether the need to fulfill the technical function was the only relevant consideration. And the German first instance court had made reference to that case law, to that decision of the Boards of Appeal. They had actually quoted it in that decision, and they had found that despite the fact that in Germany the multiplicity of forms test was a prevailing test, they found it more convincing to apply the approach by the boards of appeal, and therefore they declared it invalid. And obviously, second instance court was not really inclined to simply follow that approach by first instance, and they decided to ask for preliminary ruling. So what are the answers? With regard to alternative designs, the Court of Justice made it clear that Article 8.1 applies irrespective of any alternative designs. So that is the end of the multiplicity of forms test, certainly in Germany and certainly for the office. It's a confirmation of our approach. But what is decisive if there were only exclusively technical considerations, and that is to be assessed, and this is a phrase you have read many times, taking into account all objective circumstances, which in itself is not very helpful. No need to consider the perspective of the objective observer, and here objective observer and reasonable observer is synonymous. The fact that it's here an objective results from the translation from the German case as presented in German and then retranslated into English, but objective and reasonable means the same. And that is only clarification because, of course, as the office and as a court, if you decide from your point of view. You may disguise it as saying it's the reasonable observer, but in the end it's you taking the decision. So what are the circumstances and how to go about of that? The conclusions. The invalidity applicant must prove technical function and circumstances that dictated the choice of features. So this is very clear from the judgment. They made reference to the Advocate General's opinion, and he listed all the things the invalidity applicant must prove, and it's clear that it's for him to prove the technical function and the circumstances. And the design holder may prove considerations other than technical. Interestingly, in the first instance decision of the German court, they made a witness hearing. They invited the designer of the Dossaram welding pins and interviewed him on the considerations which had led to the design. And when you read the decision, it's quite interesting that he really emphasizes that it was only technical, because he explains in detail that in the automotive industry, basically every car manufacturer has different requirements for the welding pins, and the aim was to offer a pin which could be used by any car manufacturer. And that was the great advance, and that was what his aim was in the design. So he himself made it very clear that there were no aesthetical consideration, and the invalidity applicant also had submitted advertising material from the RCD holder, where again there was no reference to any design features. Everything was highlighting the great technical improvement of those welding pins, which the court also took into account as proving that there were no design consideration at play. But the alternative designs can play a role in that context. So if, as a design holder, you want to disprove technical function, there you can make reference to alternative designs, showing that since there was a choice of design, your considerations were not purely technical. So alternative designs are not completely out, but they're shifted in their relevance. Before, it was sufficient just to show alternative designs, to say, okay, there are alternatives, therefore the design is not purely technical. That no longer works. But as a design holder, you can show the alternative designs and explain in conjunction with the intention of your designer, who hopefully then will testify in the right way, that there were other considerations at play. And what is important for us in practice, it's a purely evidence-based assessment. And that for us is very helpful, although we have seen in the cases pending before us now that if the parties do not plead carefully, the case will fail not because 8.1 does not apply, but because the evidence is no good. So we will move to a much more evidence-based assessment. That is at least what we expect. The last one of the court judgments, the wheel rims related to spare parts. Two preliminary rulings, one from an Italian court and one from the German Supreme Court. I have reproduced the pictures from the German case because that was better accessible for me. So RCDs of Porsche AG for alloy wheel rims and the accused designs by a spare parts manufacturer from Italy. And the question was whether the Italian company could rely on the spare parts exemption or not. And the questions asked, there were three questions. The first one was, is the repair clause subject to the condition that the protected design is dependent upon the appearance of the complex products? So that's, is it limited to the must-match products as suggested in the legal review, which we have seen earlier? Must the replacement part be aesthetically identical? And what is the obligation of the manufacturer if you want to invoke the repair clause? What is his obligation to ensure that it's used for repair only? And the answers. On the first one, the repair clause is not subject to the condition that the design is dependent upon the appearance of the complex product. Basically by making reference to the wording of Article 110, which does not, unlike Recital 13, does not make reference to such dependency. So that means, in the result, it's not limited to must-match only, but the spare part exemption from protection can also be applied to spare parts which are not dependent in appearance. Of course, the argument here was, since the dependence on appearance is mentioned in Recital 13, therefore Article 110 should be read exactly in that way, but the court turned it around and said it's from the preparatory work. It is clear that initially there was a provision and a proposal to introduce that wording into Article 110, and since that provision was abandoned, irrespective of that it remained in the recital, it was clear that the legislator's intention were not to make it dependent, and therefore it's not limited to must-match. So that recommendation of the legal review, again, has been made redundant by the court's judgment, I would say. The replacement part must have an identical visual appearance. So if you want to rely on the repair clause and want that exemption from design protection, it has to be visually identical. So that's a limitation in a way. And that is on the basis that repair does not cover replacement for merely aesthetic purposes. So the idea of the repair is to restore the original appearance. And if you want to restore the original appearance, then obviously you need visually identity. It's not just to restore the object as such, but to its original appearance. I think that is very straightforward. And finally, there is a duty of diligence by the manufacturer in the form of clear and visible instructions on the product. I mean, those are details which then the national court will have to see on the concrete case. So the conclusions. The repair clause is not limited to must-match. No dependence required. You can invoke it if it's a visually identical part to restore the original appearance, and there's a duty of diligence. That judgment clearly goes in favor of liberalization of the spare part market. In the comments of the user associations to the legal review, they have heavily advocated that there should be a reform irrespective of whether there will be an agreement on the spare part clause. This is a highly political issue. You have seen before that there was a commission proposal in the world for 10 years and then abandoned. So stakeholders are very concerned that the legal reform will not be able to come through because no agreement on the spare part clause is going to reach. But I think this judgment is probably very useful in aligning the views. At least that's our hope in Alicante. The German Supreme Court has not decided on the case yet, so we don't know what they made out of it. But I think the instructions from the court are rather clear. With this, I will leave the Court of Justice and move on to the General Court, again with a picture. To give you an idea, this is the main courtroom, which I'm afraid is not so often used by the General Court. But when I uploaded the picture of a normal courtroom, the picture quality, for some reason, was so poor that it looked rather obscure. And I thought, not to give you the wrong impression, this is how it looked like, more or less. And I think if you ever have a chance to go, the most impressive for me was that you get a headset and you can really, while you're listening, you can click yourself through all the 24 languages because it's all translated. And that's, you have, I only went once, but it was a Danish, it was a representative from the Danish government speaking, and then you could listen to her in Romania, and in Polish, and in Italian and Spanish. I found that really fascinating. I cannot tell you the details of the case because I was going through all those languages and I was really impressed. So if you have a chance, you should go for that reason alone. Going back to designs, the baskets for bicycles. You see the contested RCD on the right, prior designs on the left. And what is interesting is the background to the case, because there had been an invalidity application filed against exactly the same RCD and rejected on the grounds that disclosure had not been proven. Basically because the pictures, the catalogue pictures taken were of rather poor quality. And then a different invalidity applicant filed a new request for invalidity, and on that request the RCD was declared invalid because disclosure was proven, and as you have seen from the images, the issue of individual characters is not really difficult to decide. So the main argument of the RCD holder was that the invalidity application, the second invalidity application, was inadmissible because there had been a previous one that had been rejected, and on that ground, on the principle of res judicata, it was not admissible to attack the same RCD twice. This is a situation we have quite often, because to file an invalidity application, you have to do the proper substantiation, and you have to attach the evidence of disclosure. And the invalidity, very often on the first go, they don't get it right. And then either the same invalidity applicant or another one comes back and with better evidence. And here the court confirmed our findings that the second invalidity application is admissible because Article 52, paragraph 3 CDR, only talks about res judicata if the case has been decided by a community court. You see, at the end of the provision, has been adjudicated on by a community design court and has acquired the authority of final decision. Sorry for the typo. So the court confirmed what we had said. The office is not a court. On top of it, the parties are not identical. Here the court also elaborated on the fact, because the second invalidity applicant was a client of the first one. The first one was the manufacturer of those baskets, and the second invalidity applicant was one of his clients, and the court said clearly the fact that there is a manufacturer-client relationship is not sufficient to conclude to any abuse. I mean that basically the parties were identical and there was just an abuse of that relationship. They denied that aspect. The proceedings before the office are administrative, no court proceedings. So also there are no analogy to res judicata before the court. And in particular, no analogy with Article 63 of the new EU TMR, which you see on the bottom left, because the trademark regulation has been amended in the 1617 amendment. It has been added that this also applies to decisions taken by the office. The provision was identical to the community design provision, which says res judicata only if it has been decided by a design court, and that had been amended to include decisions taken by the office. And here the court made it clear that there was no room for analogy because there was no laguna. It was clear that the legislator wanted to limit that res judicata effect to decisions by the court. And there was an explicit provision required, as proven by the trademark regulation, because an explicit provision had been introduced. And they explained, and I think that's a very interesting read, they also explain that in nature, design invalidity proceedings are different from trademark invalidity proceedings, which I found a convincing argument because the registered community design is an unexamined right. We do formal examination. We only examine on substance whether the design is for a product to be protected as a design, but we do not examine novelty and individual character. Unlike in trademarks, where you have first the examination, then it is registered. So in invalidity proceeding, you already have more or less like a second examination, and that is very different from designs. And I think it's a good argument, because in designs it basically means if you get it wrong in the first go, then there's no chance to get rid of a design which might be obviously not on the register for good reasons. I mean, as you can see in that case, it's clear that there's lack of individual character. And if you just make a mistake in the first invalidity application, it might be rather harsh in view of the fact that the design is not examined in the first place to conclude to inadmissibly. So I think that's an interesting aspect touched by that judgment. And they also confirmed disclosure. Here, the main argument of the RCD holder had been that since the evidence consisted of catalogue pages, there had been previous decisions of the boards of appeal where catalogue pages on themselves had not been accepted as sufficient evidence. That is true, but basically the distinction we make when you come up with catalogue pages, it's a big difference whether you present your own catalogues or whether you present catalogues from third parties. If it's your own catalogue, usually we would like to see some evidence that the catalogue actually has been distributed, in particular if you only send us the copy of the catalogue, or even worse, if you only send the draft of a catalogue, where you can see that a catalogue page has been created on the PC. You can see it by the frame that it's a draft, and there's no evidence whether that actually went into print, was distributed, and so on. If you come up with catalogue pages from third parties, we assume that the fact that you as an invalidity applicant have been able to obtain those catalogues, that is sufficient evidence that they have been distributed, because otherwise you would not have been able to get hold. Obviously, the holder did not go into that distinction. This is just for your information. And that also we made an incorrect assessment of the sector concerned, because those catalogues had only been distributed to traders. And if we had taken into account the right public, we would have come to the conclusion that this sector concerned could not have reasonably become aware of the disclosure. And then those arguments were rejected first, and that is very helpful for us. As in trademarks, we are not bound by our previous practice, which is good because it means we're not bound by our own mistakes also, and that the relevant sector also includes traders. If you will recall the gazebo preliminary ruling from the Court of Justice, where there were also only catalogues sent to various traders. The court made it very clear that they form part of the relevant sector. And the issue of whether the relevant sector can be expected to, reasonably be expected to have become aware of the design is something which the design holder has to establish if he wants to challenge the event of disclosure. So there is no infringement of his right to be heard. This was his argument. His argument was, since the board failed to come to the conclusion that it could not reasonably expected that the trade had known of the disclosure, his right to be heard had been infringed, because we would have had to inform him that we were taking this position. This was rejected on the principle of how to establish disclosure, and of course in the assessment of individual character. And I will not go into detail into that, because if you look at the pictures, I think it's obvious that they both produce the same overall impression. And the next one, the Cox case, is again on disclosure, and I think it's helpful because it repeats and it summarizes the principles of how to establish disclosure in a very nice manner. You see, as the prior designs, pictures taken from the holder's web page many years before he filed the RCD. The bottom picture makes reference to an international boat fair in Fort Lauderdale in the States, and the one with the green background, that is a reference to one of his distributors. And the main picture on the top left is where he shows his products. And the contested RCD, which I assume you will all know as a real product, is on the right. And here again, it's important to look at the background. The RCD had been declared invalid in 2010 by the Boards of Appeals. The RCD holder had filed an appeal to the General Court, and those court proceedings were closed because the invalidity applicant went into insolvency. And for some unknown reasons, the RCD stayed on the register, which you could challenge as a procedural consequence taken by the office, but that was a fact. And another invalidity applicant came with a new application for invalidity based on the same evidence. What he did, he took from the first decision, which is published on our website, he extracted the images of proof of disclosure and added that to his request. and the first instance rejected the application for lack of disclosure, saying that the quality of the pictures was so poor that it could not be established that disclosure had taken place. What the invalidity applicant did then, he requested file inspection, he got better copies of the evidence, and with the appeal before us, he filed those better images. And we accepted that as belated evidence because, as a matter of principle, you have to establish disclosure in first instance with your invalidity application. But in that case, we said this is supplementary because the pictures were identical to the ones filed in first instance, and that could be clearly established. And we said better pictures, that is just supplementary. And we found that disclosure was good. So on appeal, obviously the design holder only challenged the disclosure, and the court made it very clear that there are two steps in the analysis. In the first step, you have to establish whether the evidence submitted by the invalidity applicant is sufficient to prove an event of disclosure. So was there some disclosure somewhere of the prior design? And then in the second step, you look at the evidence submitted by the design holder and you ask whether that evidence is sufficient to challenge the circumstances to the effect that they could reasonably prevent this event, as established in the first step, from becoming known in the normal course of business. So once you have sufficient evidence of an event of disclosure, it is for the design holder to rebut that evidence. This is important as regards the burden of proof. That principle was first established in the umbrella case, but here it is confirmed, so I would consider it as standing case law. And what were the holder's arguments? The holder's arguments were that his website had only been visited in the US and not from customers in the European Union, that it had not been linked on other sites, that it had not been searchable, so in all these events which would then prevent the relevant trade circles from becoming aware of the website. And here the court said, no, it's sufficient that the website is technically accessible. It's not material how many people actually visited it. If it's technically accessible, then it is this event of disclosure. Search engine is not the only way of becoming aware of a website. You can advertise your website, you can show it on a trade fair, and you have a screen on where your website can be visited. And there's no quantitative threshold. So it's not important how many people saw it. That's linked to the technical accessibility. If it's out there, if it can be viewed, then it's disclosed for the purposes of Article 7.1. And the second argument on that for our practice is also very helpful. The holder had argument that the negative facts, the fact that it had not been accessed by the relevant trade, could not be proven. And here the court answered that there were various ways of disproving the event of disclosures. For example, that there was, and they listed what the design holder could have done and hadn't done, that there was no traffic from the EU on the website, that at the Fort Lauderdale boat show, which was the picture at the bottom, there were no exhibitors or participants from the EU, so that would, I assume, include a list from the trade fair organizer of participants. That the distribution network had not been operational. I'm not sure how you're going to prove that. And that no orders from the EU had been placed. I think that is also difficult, because if you send in a list and say, okay, this is a list of orders and there's no one from the EU, you will always wonder that maybe all the pages with the EU orders have not been attached. So I'm not sure about the last two ones. But I think the the data traffic aspect, that's probably a very, very good argument. So, sorry. So here the result, same overall impression. I didn't include it because I thought the case was in that aspect very obvious. And then I will move on. Boards of appeal. One of the a picture which shows you the two new buildings on the left side. I hope that has been the end of the construction work at the office premises for at least a couple of years, because although it's very nice when it's finished, it's awful while it's going on. So boards of appeal. The first case on Grand Board case on designs. The prior design on the left for a set of articles. You might be aware that we register a set of articles. That's not the same in all the member states. We have been confirmed by the court in that aspect that if there is, if all the designs follow the same aesthetic principles and if they're used for the same purposes, so some functional complementary function, then we can use it we can accept it as a set. And the contested RCD on the right, the basic idea for the referral from the third board to the Grand Board was to get a decision on a set of articles, whether we should accept them or not. When we discussed the case, it was clear that basically, if it's a set of articles, it's a prior design, you have to take the prior design as invoked by the invalidity applicant. You cannot enter into the question of whether that's a valid design, because it could be a picture from a catalogue, it could be anything. So we abandoned our original idea and came to the conclusion that yes, there is individual character. Sorry, I will go back for you to have a closer look at it, because doing the comparison, we looked at the cover plate. You see two plates, and we said which comes closest to the contested RCD is the top plate. And looking at the top plate, there are various differences as regards the height, the transition between the edges, which is rather smooth and more edgy in the contested RCD, and that the bottom surface and the glossy surface, the bottom lines, the square lines, and the glossy surface, which you see on the RCD and which are features not disclosed in the prior design, because in the prior design you can only see the top view and not the additional aspect, how it looks from underneath. That overall was sufficient to create a different overall impression, taking into account that the design freedom is average, or as we said, unlimited, and that case is pending before the court. And I, of course, would be happy to have your feedback on that one. Two cases on facelifting, what we call facelifting in the automotive industry. The background of the case is that the invalidity applicant is a manufacturer of toy cars, and obviously they don't want to pay licenses for every new toy car model they make, and they filed an invalidity application against the RCD based on prior designs of the RCD holder. That was the background. We found different overall impression. The main argument was, is there a limitation of the design freedom with regards to market expectations? Because if you have a car model successfully introduced into the market, of course, there is some expectation that it will be modernized. Is that a limitation to the design freedom? We said no, but the informed user is aware that with cars, you have that facelifting aspect. So you know that a car model will be modernized and that there is a compromise between maintaining the main characteristics and introducing modernizing elements. And there was also an argument about on what level you do make the comparison, and the invalidity applicant had argued that you do not make a side-by-side comparison, but you compare from your imperfect recollection. That's a trademark argument which we rebutted. You look at them side by side and you will see overall, going through all the elements, which I will spare you here, that the overall impression is different in the sense that the informed user of cars will be able to distinguish the models. The parallel case, also pending before the court, is the Porsche, where we, with all effort, hardly couldn't see any differences between the contested RCD and the prior design. So here we confirm the lack of individual character. Here the main argument was that the informed user is the driver of Porsche 911. And we said no, the informed user is the informed user of cars, because the main argument was that if you have bought a Porsche in 1960 and you buy it in 2000, you will know exactly the difference, and we were not convinced by that. There were also consumer surveys offered, not submitted, but offered to prove that the average Porsche driver would be able to see the differences, and we said no, the informed user is not the end consumer, and therefore consumer surveys are irrelevant in the assessment of individual character. And also, the informed user is not a design specialist, because, of course, Porsche has received many design awards, and also different design awards for different series, because that basic model has been modernized many times. And for some of those modernizations, they have received design awards, also for the one in issue. And we said this is not relevant. And of course, you could also say that both cases have to some, I would not say a political implication, but discussing the case, we found it very difficult because all three of us, looking at the Volkswagen, we could immediately say that they were different, but you're somehow spoiled, no? Because like myself, coming from Germany, having grown up with Volkswagen, it's maybe not the informed user on the broad scale. We were not sure about this case. We were very much hoping for clarification from the court, because also within the office we have discussed it very controversially. So I'm happy to have your comments on that one. And the last one, because when I drafted the presentation, I thought, oh, maybe we're approaching breaks, and I put in some sweets. I realized that's not the case. You're really hardworking. This is also, just read this morning, pending before the court. And this is my last decision to present, because it touches on the issue of internet disclosure. As you might be aware of, we have a convergence program with the national offices regarding the relevance and the reliability of internet disclosure in the assessment of design invalidity. And here two designs were submitted. The prior design was a picture of a packaging for a product on the market in 1997 for a very short time. For those of you able to understand German, it says für Kinder, and in Germany we have Kinderschokolade, a chocolate called Kinder, heavily defended by Ferrero, the trademark owner, and therefore Danone within a few weeks took that product from the market, or were invited to take it from the market. And second prior design was a Wikipedia article which referred to a product which in Germany is called as Milchschnitte. And you see the contested RCD on the right. And the first instant had based this on the packaging, and we took the Wikipedia article instead, because with regard to the packaging, there was a lot of arguments whether disclosure in 1997 was historic and therefore to be disregarded. And we didn't really want to go into that. Personally, I think that it is not historic, but never mind. So we looked at Wikipedia, and although the article did not, obviously not establish the exact date of disclosure, it nevertheless made reference to that product, the Milchschnitte, having been launched in the market in 1978, and since that was years before the contested RCD, we took that into account as sufficient evidence, and you can say 78 is even older than 97, but with this product it's no issue, it's still on the market. So it was launched in 78, but it continues to be on the market today, so that was not a problem. And it was also not contested by the design holder. And we said average design freedom. There was some argument as to the limitations in terms of production when you do this type of biscuits. Well, we said no, it's average in general. And we concluded to the same overall impression with the argument that the dark streak in the middle, that was the main argument, that would make all the difference also when you open the package, that it would be what you see at first sight. And we said, no, that's just an addition of flavor, and the contested RCD as filed does not show how you will see it in the packaging. That's an argument which you cannot see from the representation as to be taken into account by us. So, thank you very much. Since I used up all my time, of course, for any question, I'm very happy to answer them in the break, at lunch, or if you would allow.
No, I think you still have, you manage quite well, so
okay.
We still have a time for questions. So if the audience want to ask about the new reform or some aspects of it, or the current case law, and maybe you would judge differently as was shown by the higher European bodies, so please, the floor is yours.
Yeah, in particular with regard to the cars, I would be very interested whether you had similar cases, or whether you would have taken similar approach on the facelifting aspect.
Varētu mikrofonu uz pirmo rindu palūgt.
So here we would need a mic.
Very interesting presentation. I think it will be very useful. We haven't had many design cases, just very few, and not about cars, something like that. But when we will have, so we'll be able to have a look on your presentation, and we will have an easier discussion then. What I wanted to ask you is, what do you think is the biggest challenge regarding the new reform of design law in Europe? How do you see, what will be the biggest challenge in future regarding design law?
I think as regards the provisions, from the perspective of the office, and we will be certainly very much involved, I think the challenge is not to assume that trademarks and designs are the same. We had a huge trademark reform. We had a lot of workforce going into that. For trademarks, you might not know, but to harmonize our practice within the office, we have so-called knowledge circles, where people from the different departments of the office discuss different aspects. And those knowledge circles were heavily involved in the trademark reform. And for trademarks, I think we have 12 knowledge circles. We have one for absolute grounds, we have one for relative grounds, for list of goods and services, for procedures experts, for the registry, for transfer, for you name it. For designs, we have one knowledge circle. covering all that, and the tendency, from my personal perspective, is to say, yeah, we do it like in trademarks, and I think there are certain aspects, and this is why I put so much emphasis on the bicycle basket. I think there are certain aspects which are different, and which should be taken into account. We have now quite harsh provisions in trademark proceedings as regards substantiation, as regards belated evidence. Obviously, it's all meant to streamline, to make it more efficient, but I think for invalidity applications, we're talking about a different audience. We still receive, we have also different stakeholders. The people filing and the representative in trademark cases are not necessarily the same who do the design cases. I think we should we should be more lenient in that case. Personally, I'm worried that we're getting very, very strict, and if you're not really go to a highly professional representative, you're not going to make it, because you will be stopped at the first hurdle, lack of substantiation. We have a problem with online substantiation. We accept that for trademarks now. If you invoke in opposition proceedings an earlier trademark, you can refer to the online database. You don't have to submit the certificate as before. In designs, you might accept that for the design view, for the database, but the evidence of disclosure is much more difficult to gather. And I think we should be more generous there. This is my personal concern. On a broader level, if we introduce invalidity proceedings in all the member states, I think that would be a great challenge for the member states, but also for us to harmonize the practice there. And I think it's also a certain risk to jumble too much. Design is very fashionable at the moment, 3D printing, all the future. But with the trademark reform, we had the experience that we submitted a draft, and we submitted the draft in the expectation that then we would later on get a possibility to fine-tune it. The draft went into extended consultation with the member states, but in those consultations, the provisions most controversially discussed were those about cooperation between the member states and the office, distribution of the budget, of the surplus of the budget. Many provisions were which were of no relevance in terms of substance. And that was an interesting experience, because we did not get a chance to fine-tune the substantive provision. To a certain extent, yes, at the very end, but not to the extent hoped for, and they were not discussed to the extent we expected. So I'm very happy about this evaluation roadmap, which is much more extensive than done for trademarks, because it will give us the possibility of gathering a lot more information, what is really the interest of stakeholders, but it will be the challenge to balance the interest and not to get carried away by saying we do it as in trademarks, or we do it because we have to introduce changes. As I said before, I think on substance, from my experience, the provisions work very well, and I'm very much in favor of case law. I'm not so much in favor of putting it all in the provision. In trademarks, we know we have the provision on distinctive character. If you read it, it doesn't say you anything. I mean, whenever you have given a basic lecture and it reads if it's able to distinguish goods and services from one enterprise to that of other, what does it mean? But I think it has worked perfectly well.
Thank you. And one more question. How do boards of appeal, what is your look towards, and how do you apply the consumer surveys? You already touched upon that when talking about motor vehicle cases, but which would be those areas when you really use, or maybe you say, okay, we do not see much use in consumer surveys, and when you have them, is there any percentage that is sort of, you have decided, okay, this percentage should be enough for that, or not, or it's in each case different, or let's say, is 30% enough for some things, let's say, or it should be more than 50, or I know it's a big debate in all countries,
Yeah.
so, but is there any practice in boards of appeal regarding consumer surveys?
I think the practice is to be very restrictive. For designs, we discard them. As I said before, the informed user is a legal fiction. He has a higher knowledge than the end consumer, so we do not see any use there, because you cannot make a survey among the informed user if the informed user as such doesn't exist. For trademarks, the hurdle has been very high now, that in the way that you have to show it in all the member states where there exists the lack of distinctiveness. So most surveys, although we take them into account, they fail because they do not cover all the relevant member states. If they do not fail on that aspect, usually it's very difficult to ask the right questions and to get the right answers. I will give you an example. The main cases we see surveys are in colors, three-dimensional shapes, color combinations. I had a recent case of a color combination. It was for scissor lifts. It was for how do you say that? In construction industry and maintenance industry, airship maintenance, aerial working platforms. So very specific product that is good under the Orange case law. And they had used the color combination, and I can talk about it because the decision is notified, orange and cream. And they had asked professionals in that area, and they had shown to our conviction that the market was limited and that a sample of 200 professionals in that area is sufficient. And then they had asked different colors, orange cream, black and yellow, and received answers. But for example, on the orange, they were named as often as on the orange and cream. So what does it tell me? Does it tell me they use a combination? Or does it tell me that they should have claimed orange? They had sent in a lot of material where you could see that they had shifted to the orange and cream only 5 years ago. It was not a combination they had used for many years. They had used the orange for many years, and then for some reason they added the orange, the cream. I think probably very often it's to do with imitations on the Chinese market, and they want to enforce it. I mean, I can see the position, but the evidence, the survey, combined with the other evidence they submitted, it was not convincing. You could feel their interest in getting the color combination, but the percentage is the least. Very often we do not come to the point where the percentage is relevant, but we're not bound to a specific percentage, and the smaller the market, the lower the percentage. For example, for that specific type of good, 25-30% for me, that would have been sufficient. If you have a consumer good, if you have like cookie I've just shown you, then you need at least 50%. I mean, it depends a lot on the public you're looking at. But I think the biggest problem is to get good evidence, and I think the only case which went through without any problems and was confirmed by the court is the John Deere agriculture equipment, the color combination yellow and green. The evidence was so vast. I mean, you wouldn't even have needed the survey. But it shows you what is at the very end, where we did not accept the evidence. To give you something on the end where we denied it was the Goldhauser, the chocolate rabbit from Lindt. The trademark fight was the rabbit without the word Lindt, because if they put Lindt, then it's no issue of distinctiveness, but they wanted it without the Lindt. They submitted massive amount of consumer surveys, but they all were from either April or May of specific years. But the product they claimed was chocolate products. I mean, they did not claim chocolate products to be sold at Easter. And it was clear that if you make a huge advertising campaign for Easter in April and then you have the survey in May, you get huge results. But if you have chocolate in general, what is happening the rest of the year? So it's usually the combination of the survey evidence with the other evidence and with the goods you're asking for. Very often, if they would limit the list of goods and services, chances would be higher. But if you have a very broad list of goods and services and you actually use a trademark for a very specific product, then you're never going to make it, irrespective of the percentage you see. Okay? Yeah.
You're just following up on that question. Would you accept evidence from the trade, from a distributor or something, saying, yes, people come in and ask for the orange and cream platform, and we always, what they want is the applicant's product?
We would accept it, but the experience shows that very often it's, and that was exactly the case in the cream and orange, it was a prefabricated questionnaire. And then they had sent it to different clients or distributors and who were meant to fill it in. And it was interesting because those who had, I assume those who had understood the instructions had, and I always know that they mean so-and-so, or this clearly indicates me that I'm talking about a product of X. But there were also distributors who said, I don't really know what the color is about. I mean, it's very tricky because when we see it, it's always induced by the right holder. It's very difficult to get that objectively. In Spain, if it's a Spanish trademark, the Trademark Association, it's like a prefabricated statement. It's always the same in all the files, and it says has been used for many years and clearly indicates to the trademark owner and seal and stamp and everything. And we say the evidential value is limited.
But if I can abuse my possession of the microphone, is the question of the capacity to distinguish or whether it in fact distinguishes? Because the implications of the evidence are different.
It's whether it's perceived as a trademark. And for example, what would be useful, but we would never see, if it's emphasized in advertising. They submitted reports. They had been at many trade fairs, and they submitted articles about, and those articles, you know how it works. They make a press release, and then the journalists copy more or less the press release. And there was only one single press release where it said, and company X, and in its usually orange and cream livery. If we had had more articles about that, that would have been marvelous. But you have to enforce it in your advertising. You have to add it to your trademark that this color is linked to you. I think with colors, use of the color alone is not sufficient. And if you do that properly, I think it will work. But this is, for us, it's a perception, not the ability, but whether it reaches consumer as a trademark, as a trademark message. That is at least for shapes and colors. And this is what we say because it's not distinct from the product. So if you want to use it as a trade indicator, you have to communicate it to the public. And if you have successfully communicated, they will perceive it. But if you don't communicate it, then it's just the color of the product. Okay?
Yes, I would like to thank once more Ms. Fink for this marvelous presentation.